The South African government has issued a gazette easing broad-based black economic empowerment licensing requirements for satellite services such as Starlink. This sets a precedent where one type of company, such as foreign tech companies, is allowed to bypass rules that all others in the local private sector must follow. This gives South African companies the legal precedent and the opportunity to demand the same exemption from BEE compliance because under South African law, all laws must be applied equally, as this is a foundational principle under the Constitution of 1996. Section 9 of the Constitution, the Equality Clause, states that everyone is equal before the law and has the right to equal protection and benefit of the law, but naturally it allows for affirmative action measures to promote substantive equality, which in and of itself is an oxymoron to the Equality Clause. Yet, what it does not allow is for subjecting some individuals to affirmative action while it gives special protection to others. Equal application is required unless the difference in treatment can be objectively justified, often on the basis of promoting equality or redress, but in this case it shows that BEE is not justified as certain sectors can be exempted from the yoke of affirmative action. It will be difficult for the state to rationally justify the exemption, and therefore it sets a precedent to get rid of all laws giving preferential treatment to one racial group while giving punitive treatment to another. This means, legally speaking, the state just gave grounds to get rid of all BEE measures in this country, meaning this is a very positive development, even though it is a kick in the teeth for all South Africans who suffer immensely under black economic empowerment legislation. In this video, we will explain why. Good day, dear friends. This is Willem Petzer speaking. Be sure to subscribe for more analysis like this in your interest and join our WhatsApp group to keep you up to date with all the work being done by the Willem Petzer group. Just WhatsApp your name and surname to the number on the screen to join. The work we are doing is having an impact on a global scale, and now is the time for us to stand together and take the struggle to the next level. Even if you're already on the WhatsApp groups, you can still help us keep going and growing by subscribing for a small monthly fee. And to do this, just send sign me up to our WhatsApp number still on the screen. We really need and appreciate your support. The South African government is now actually considering easing BEE regulations to allow Elon Musk's Starlink to operate in this country. Last Friday, the Department of Communications and Digital Technologies, led by Minister Solly Malatsi, published a truly groundbreaking new proposed policy direction for the country's communications authority. Until now, as is well known, Starlink has remained banned from South Africa because it lacks the necessary black ownership requirements set out in Section 9(2)(b) of the Electronic Communications Act of 2005. Here it is outlined that in order to achieve a license to operate in South Africa, companies must have at least 30% black ownership. Now, Malatsi's department is considering easing this regulation because it believes that the importance of increased investment in ICT and the need for universal internet access is so important to advancing the living standards of South African people that it should trump the country's BEE regulations. In fact, the proposal states that even a 10% increase in broadband internet participation results in a 1.2% GDP growth in middle-income countries such as South Africa, and that, and I quote, giving millions of South Africans access to broadband would constitute one of the biggest empowerment programs in South African government's history. The Department of Communications and Digital Technologies has hereby admitted that because of BEE, millions of South Africans are being denied important economic opportunities. It must of course be recognized that the only reason the government is now considering funding a way for Starlink to operate in this country is because the absolute embarrassment it has become on the international stage over the past few months, but especially with the last week's disastrous visit to the White House, where South African President Cyril Ramaphosa was embarrassed in front of the whole world when footage of members of our government, such as the EFF leader Julius Malema, calling for genocide of white people in South Africa, was played in the White House for all of the world to see. The government of this country was thereby humiliated in the worst possible way. Elon Musk himself was present at the meeting and locked eyes with Ramaphosa in a confrontation which highlighted Musk's frustration concerning South Africa and Starlink not being able to operate. Speaking virtually at the Qatar Economic Forum last week, Musk also specifically slammed what he described as South Africa's racist laws, referring to the 140 BEE laws currently in place in South Africa that discriminates against white people by aiming to exclude them from participating in the economy on equal footing.
Bloomberg broke news today that the South African government is working around the rules on black ownership in order to allow Starlink in, and that is being done on the eve of the visit that President Ramaphosa is going to make to the White House. Do you recognize that as a conflict of interest?
No, of course not. First of all, you should be questioning why are there racist laws in South Africa? That's the first problem. That's what you should be attacking. It's improper for there to be racist laws in South Africa. The whole idea with what Nelson Mandela, who was a great man, proposed was that all races should be on an equal footing in South Africa. That's the right thing to do, not to replace one set of racist laws with another set of racist laws, which is utterly wrong and improper.
It therefore seems evident that the sheer amount of negative international attention that South African government has received recently has successfully pressured them into making this concession for the richest and one of the most influential men on the planet. But what is particularly interesting is that this new and revolutionary policy proposal is based on an amendment made to the country's black economic empowerment laws as applied to the information and communication sector way back in 2016. That amendment stated that when it comes to operations in South Africa, technological companies must have what is called BEE equivalents, recognized in the place of black ownership requirements. And how are these equivalents calculated? Well, it is per the government's own regulations measurable against the value of their operations in the Republic of South Africa. What Minister Malatsi and his department are proposing, therefore, is not just making a concession for Musk. What they are proposing is that the government applies the socio-economic value of Musk's enterprise as a measurement, exempting his company, Starlink, from the legal requirement of 30% black ownership. While the relevant amendments were referenced in last week's government gazette within the context of multinational companies which, because of their global nature, may be constrained from complying with equity ownership requirements, the actual amendment known as Statement Act 103 as part of the Codes of Good Practice on Broad-Based Black Economic Empowerment does not expressly limit the application to multinationals. It was, of course, specifically designed for the ICT sector, which in itself implies that this exemption is made to Musk's company. A whole host of information technology companies could potentially apply for similar exemptions, and even take the government to court for discriminatory practices should the government refuse to grant similar exceptions to all of these other companies. This possibility is distinctly opened up by the fact that this proposed policy shift by South Africa's Department of Communications and Digital Technologies specifically aims to reconcile the country's black economic empowerment framework with the pressing need for technological advancement, because in its conclusion it implies that technological advancement is now more important to the country's well-being than affirmative action. It calls for the South African Communications Authority to urgently consider alignment of the regulations with respect to the limitations of control and equity ownership and the application of the ICT sector code with the amendment of the BEE ICT sector code. Such a step would set a revolutionary legal precedent as it signifies the South African government's willingness to relax BEE requirements for the sake of advancements in the information technology sector. At the very least, this opens the door for other tech companies to challenge BEE requirements, potentially reshaping South Africa's ICT landscape and sparking legal debates over equitable application of the law. Furthermore, the standard for granting exemption proposed by Malatsi's department is an extremely broad one. If the value a business such as Starlink adds to South African economy can be counted as the value of their operations in South Africa per the regulations of government themselves, why wouldn't this apply to any other profitable enterprise operating within the borders of this country? In fact, the data actually makes the case that it does, and that Malatsi's department has now effectively admitted that it does, as I will now proceed to explain. A 2024 study by South African Institute for Racial Relations shows that BEE regulations is costing South Africa 150 billion rands annually. This amounts to more than 2% of our entire GDP, meaning that scraping the country's BEE laws would immediately increase our standard of living and make South Africa wealthier. Moreover, the findings of the study have been vindicated at the World Bank, the very institution to which the government is now appealing to justify its proposal to relax BEE measures for Starlink. The fact of the matter is that the Department of Communications and Digital Technologies has now officially admitted that the regulatory hurdles placed upon private enterprises by BEE hurts poor South Africans economically. This amounts to a profound admission. The very government that has implemented BEE for over 2 decades is now admitting that, in practice, it is failing at its stated objective and, therefore, exemptions must be made. The proposed new policy direction issued by the Department of Communications and Digital Technologies appealed to the World Bank's figure of 1.2% GDP growth as a legitimate measurement for easing BEE restrictions in the ICT sector. As the study by the Institute for Racial Relations indicates, however, abolishing BEE legislation, all BEE legislation, would benefit the economy far greater. The logical next step, therefore, would be to apply the principle that the government now seeks to apply in the ICT sector to the economy as a whole. The economic realities speak for themselves, and the South African government has now admitted that its own BEE regulations are hurting millions of people in South Africa. With the attention of the entire world on South Africa right now, an unprecedented opportunity presents itself, especially for international companies, to legally challenge the government's destructive BEE hurdles. Thanks for watching this video. Be sure to support us via a paid subscription. It would help us immensely. Just WhatsApp sign me up to the number on the screen. Goodbye and God bless you.